Welcome to Bracewell's webinar on environmental justice and enforcement priorities. I'm Rachel Goldman, a litigation and disputes partner here at Bracewell and co-chair of the firm's ESG practice group. With me today is Matthew Silverman, Chief of Environmental Litigation at the U.S. Attorney's Office for the Eastern District of New York and leader of the office's recently created Environmental Justice Team. Also here with me today is Seth DuCharme, the former acting United States Attorney for the Eastern District of New York and former Principal Associate Deputy Attorney General for the United States, and he recently joined Bracewell. Welcome, Matt, and welcome, Seth.
Thanks, Rachel.
Thank you.
So, Matt, you've been working in the Justice Department for many years. Can you please give us and the audience a general sense of the types of matters you've worked on and some of the partner components and agencies that you've worked with, like the Environmental and Natural Resources Division?
Sure. So for almost my entire career, I've worked in government litigation. I was with the state of New York and the city of New York before I came to the Department of Justice in 2013 in the Eastern District of New York. And I've handled a wide range of defensive and affirmative types of litigation. Starting in 2018, I started to focus my practice in the environmental sector and became the chief of our environmental litigation practice. I've worked with virtually every major federal agency, including the EPA, Department of Defense agencies, Department of Energy, Department of Interior, National Park Service, the FAA, and others. The range of litigation we deal with kind of spans the entire practice of federal environmental law, CERCLA, which is the Superfund law, the Clean Water Act, the Safe Drinking Water Act, Clean Air Act, RCRA, Toxic Substances Controls Act, NEPA, and Administrative Procedure Act cases. We also work closely with Maine Justice, the Environmental and Natural Resources Division, and sometimes also the Environmental Torts Litigation section.
Thanks, Matt. That is quite a career so far. Seth, based on your experience as the acting U.S. attorney in a very busy district and before that with Maine Justice, are you surprised that the department has recently emphasized environmental enforcement priorities? And what do you think this means for companies in the sector?
Yeah, thanks, Rachel. I'm not surprised at all that the department and that the administration, have prioritized environmental justice work. I mean, you could hear from Matt and knowing, some of his background that, lawyers in the Justice Department and the partner agencies, have been steadily doing this work. Matt and his partners have been doing this type of work for a long time, and I'm sure will continue to do so. But when a new administration or new leadership in the department, signals something as a priority, as they did with the creation of Matt's team, I think what that really does is it energizes and encourages, the people who, like Matt, who are steadily doing that work. And, this administration pretty early on signaled that environmental justice was going to be one of their priorities, issued an executive order. And the U.S. Attorney's Office in the Eastern District of New York, has tended historically to be a pretty forward-leaning, forward-thinking office. And what I expect is that, to carry forward the policy priorities and objectives, of the new leadership team, the office wanted to recognize, the great work that Matt was doing and some of his colleagues were doing and elevate that, in the public consciousness. I think one of the benefits of that is it sort of puts the public on notice that this is something the department's focused on. It recognizes, the people who do this type of work, and it starts conversations like this one. So every new administration, every leadership team, chooses their priorities. And I'm not at all surprised to see the administration focus on this or the department or the office, pick up the mantle and carry the mission forward.
Matt, this is your specialty area. So can you please explain to our audience what is environmental justice and where does it fit in within the context of environmental enforcement?
Sure. And just I have to note that I'm speaking in my individual capacity today. And so everything I say is my own personal opinion and generally based on public information. So there's no legal definition of environmental justice in federal law, as far as I'm aware. And if you speak to lawyers and advocates and the public about what environmental justice is, you'll get different answers. I typically look to EPA's definition. I'm going to read it to you. It's not very long. Environmental justice is the fair treatment and meaningful involvement of all people, regardless of race, color, national origin, or income, with respect to the development, implementation, and enforcement of environmental laws, regulations, and policies. Fair treatment means no group of people should bear a disproportionate share of negative environmental consequences resulting from industrial, governmental, and commercial operations or policies. Meaningful involvement means that people have an opportunity to participate in decisions about activities that may affect their environment or their health, and the public's contribution can influence regulatory agency decisions. Community concerns will be considered in a decision-making process, and decision makers will seek out and facilitate involvement of those potentially affected. So, if you speak to environmental advocacy groups who talk about EJ and work on EJ, they often take a more expansive view. And that's worth understanding if you're engaged in community outreach. I think sometimes groups will look at EJ as them being an equal partner with government in decision-making in terms of the substantive outcomes, whereas I think the EPA definition is more process-based, kind of like a NEPA review is. But it goes beyond that. But I think it's more process-based based on the fairness of the process and the community's ability to potentially impact the outcome of a decision. And environmental justice, I'll refer to it as EJ as it's often called, has been part of the federal lexicon, at least since before 1994, when President Clinton issued the first EJ executive order, which was number 12898, Federal Actions to Address Environmental Justice in Minority Populations and Low-Income Populations. More recently, President Biden issued Executive Order 14008, which is about climate change, but also discusses EJ, and also the administration's Justice 40 initiative, which aims across the whole of government to provide at least 40% of environmental benefits and resources to areas that have EJ implications.
Okay, great. Thanks. As you noted, the concept of environmental justice isn't really rooted in legislation or a specific statute. So what kind of challenges does that present from your perspective, from the department's perspective?
Sure. I mean, it might be helpful to have a statute or regulation at some point that addresses how environmental justice is dealt with across the government. But the administration's approach now is a whole of government approach. Every agency, down to little agencies you've never heard of, have the same charge under the executive order to advance environmental justice in all of their activities. And that extends not just to enforcement, but to, project planning, like, there are different major public works projects, whether they relate to airports or environmental cleanups or permitting actions. All of those areas are covered. From an environmental standpoint, I think one challenge is that many EJ issues don't stem from violations of any law. Many environmental justice issues are connected to local decisions, private sector decisions regarding zoning, development decisions, permits that are lawfully issued, where businesses site industrial operations, things like urban heat islands. If you look at certain cities, there are parts of the city where there's less tree cover and less parks that may be 15 or 10 degrees hotter. And those types of things are kind of a vestige of the past, and things like racial redlining that created areas that really don't have amenities that are cooling. So it's a challenge from an enforcement perspective to deal with kind of systemic issues like that have caused harm over the years, because they're kind of baked into the way that things operate in the world.
And is that one of the reasons do you think that the environmental justice team has been created by the department? And also, can you tell us a little bit about that team's mission and how it came about?
Sure. So, so our office put out a press release on the environmental justice team. It was, started shortly after the executive order on environmental justice. And the executive order basically indicates that agencies shall make achieving environmental justice part of their missions by developing programs, policies, and activities to address the disproportionately high and adverse human health, environmental, climate-related, and other cumulative impacts on disadvantaged communities, as well as the accompanying economic challenges of such impacts. And to my knowledge, Eastern District of New York is the first U.S. Attorney's Office to assemble a team specifically on that point. And that's not to say that other offices and ENRD aren't also doing environmental justice, because they are. But we, the Eastern District of New York, as noted in the press release, started this team so that it could focus its resources on these issues with a team that has 6 AUSAs and myself. Many of Eastern District of New York's cases, both now and in the past, have had EJ aspects, including lead paint enforcement under TSCA, Clean Air Act cases, Superfund cleanups. Many, if not the majority of Superfund sites in the Eastern District of New York have overlapping EJ areas. Also working on protection of drinking water resources, that's surface waters as well as underground sources of water, and wetlands, of which there are many in the Eastern District of New York, both in Staten Island and on Long Island. And wetlands are important for mitigating climate change, which has an outsized impact on areas that have EJ implications. So the team focuses and prioritizes resources on those areas. And as I mentioned, Superfund sites are a big issue in the Eastern District of New York. We have several major sites you may have heard of, like the Gowanus Canal, Newton Creek, potentially the Coney Island Creek, and the Wolf Outport site, which straddles Brooklyn and Queens.
That sounds like there is quite a lot on the team's plate. And it ties in also to, I think, a lot of what's going on in the world with ESG issues in other parts of the government, and also other areas of society focusing on these ESG principles, which many of our guests know about, the notion of responsible corporate citizenship through embracing the values associated with environmental, social, and government priorities. So, Seth, how do you see the principles and initiatives that Matt has been talking about fitting into the larger ESG paradigm, both with the government and in the private sector?
Yeah, so they're not exactly the same, but they're certainly closely related. I think in Matt's world, as he's explained, the concept of environmental justice has been around a long time. And that concept and that way of thinking and fair treatment of people and fair application of enforcement action, is what's driven the department for a long time, and certainly it sounds like is what's driving them now. ESG, I think, overlays with some of the principles and initiatives that Matt's been talking about, in the sense that, we know for decades, corporations have embraced the notion that, if you're environmentally responsible, socially responsible, and have, integrity in your corporate governance, you're going to attract investors, other stakeholders. You're going to have a good internal corporate culture, and you're essentially going to be it's the conscience of the corporation to some degree along those three principles. And I think, those notions of conscience and social conscience do intersect in a very meaningful way with how the department, launches or emphasizes enforcement actions, because it's all about really, holding people accountable when they don't meet the expectations under the rule of law. And in the corporate sector, it's sort of, holding people accountable when they fail to meet the expectations of investors, or counterparties or other stakeholders. So really where I see them fitting in, and the ESG, each of those things, environmental, social, and governance, If we're listening carefully to Matt, each of those three pillars kind of touches on some of the things that Matt has said. So obviously the environmental is a direct overlap. Responsible, environmentally sound practices, if they violate the rule of law, you'll get on the department's radar, and you may be punished. The social aspect of that, I think, relates in, what is social responsibility? In other words, if there's, for example, waste generated from a product or a project, we don't dump that waste in disadvantaged communities. We're responsible to the community as a whole, and we, in the corporate side, we treat people fairly, and we sort of look out for everybody. And then internal governance, it's knowing how you're functioning, communicating within the corporation, being aware, frankly, of the regulations, that Matt's talking about, so that there can be compliance. And I think the really important overlap is, in ESG, we see a lot of positive, forward-looking statements from corporations. Just something as simple as we are environmentally responsible, socially conscious, and we have integrity in our internal governance. I think that the government is entitled, when they see those statements, to ask, whether or not your actions match your words. And so, I can envision, and again, this is just my own speculation. I've been out of the government for 6 months now, so this is not based on things I knew when I was there. But I can imagine, as these areas of environmental justice get sort of energized, the department and other regulators like the SEC will be taking a look at some of those statements, perhaps listening to whistleblowers, and essentially making sure, to the best of their ability, that particularly when a corporation puts itself out there as being aligned with those responsible principles and aligned with the rule of law, do their actions match their words? If they do, that's good for everybody. If they don't, there can be some civil or even criminal exposure there, I think. So I think it's all about meeting expectations, both under the rule of law, most importantly, but then also, how you hold yourself out, as a good corporate citizen.
Thank you, Seth. And just turning back to you, Matt, in your world, where do you see the potential overlap of areas between civil enforcement and criminal or other regulatory enforcement actions?
Sure. So there are a number of areas where we see criminal overlap, and those are particularly comes up when dealing with cases that involve toxic and hazardous substances, things like lead paint and asbestos that are regulated under the Toxic Substances Control Act, or TSCA, and certain chemicals like pesticides under FIFRA. There have been, during COVID, a number of matters that have been public about people selling, things online that are either that kill, allegedly kill COVID or kill this germ or kill bugs and different types of things that are not legal products under either EPA or FDA's regulatory rubric of rules. And so sometimes those matters can be criminal. We also have seen criminal cases involving things like oil spills or spills of chemicals, particularly where there's intentional, reckless, or even negligent conduct. For example, there was a pipeline company in North Dakota recently that settled joint civil and criminal enforcement claims by paying a $35 million penalty after it released 700,000 gallons of the wastewater that's produced by hydraulic fracking. It was a spill so massive it could be seen from outer space. So, cases like that will often cross the Rubicon into criminal territory. EDNY has had both criminal and civil cases dealing with contractors who improperly remove lead paint. And in those are cases where the workers are either uncertified or maybe they are certified, but they're doing work without the adequate safety precautions in place. And in the criminal cases, there's often evidence of a child being actually exposed to lead paint, having elevated blood lead levels and things like that. Well, we also see criminal cases where companies or their employees make false statements to the government, destroy evidence, conceal evidence of a violation of environmental or other laws. And in those cases, there may be civil and criminal theories, including wire fraud, Anti-Fraud Injunction Act, or False Claims Act liability. Another area where there's a lot of criminal enforcement is wildlife trafficking. And you see that in districts like the Eastern District, where there's ports, airports, and things of that nature, where people are bringing things in from other countries that are illegal under the Lacey Act or other statutes.
And what about the other side of that coin? I mean, have there been notable examples of corporations or individuals taking responsibility to find alignment with the government to work for a successful outcome or remediation or any other variation on trying to work with the government to take responsibility?
Sure. And I would say that many, if not most, regulated entities handle environmental enforcement actions well and are cooperative. And really a large part of that, I think, is determined by the sophistication of that entity and also by who's representing them, frankly. There are unfortunate situations where regulated entities hire counsel that just really aren't quite on the mark of the field that they're dealing with. So maybe they know an attorney that does land use and some zoning issues, and they figure, well, I'll use them for, a Clean Air Act case or whatever. And it really is, you really do have to be pretty close on the mark because these statutes and the regulations are highly technical as well as the underlying science. And so if you're using, counsel that aren't the right counsel, you're going to have problems. There are a lot of great settlements with corporations and municipal defendants. There was one major settlement from January of 2021 where Dow Chemical settled a case with the United States and the state of Louisiana in which it paid a $3 million penalty that was split between the United States and the state. But more importantly, Dow agreed to significant injunctive relief that was environmentally beneficial. The case had involved allegations that Dow and related companies violated the Clean Air Act by not properly operating and monitoring industrial flares at petrochemical facilities, resulting in excess emissions that were harmful to the environment. So, above the penalty, the defendants in that case committed to spending $294 million to install and operate air pollution control and monitoring technology to deal with their flares and the resulting harmful air pollution at 26 different industrial facilities in Louisiana and Texas. We've had in Eastern District have settled cases with similar issues, like on a smaller scale. In 2020, we settled a case with the town of Brookhaven involving landfill emissions. And in addition to paying a penalty, the town implemented a supplemental environmental project where they would install solar panels, which would reduce their overall emissions profile, and installed a number of systems to monitor landfill gases, flares, and the temperature of the landfill that could result in underground fires and other issues. That was one of the last cases with a supplemental environmental project. We call them SEPs, that was filed before the prior administration had put in place a regulation and policy to stop those projects.
Well, Seth, Matt mentioned that it's very important who the counsel are that's representing the companies that are facing enforcement actions from the government. When you were the U.S. attorney and with Maine Justice, you dealt with outside counsel for corporations seeking relief from the Department of Justice quite a bit. What were some of the approaches that you saw that worked? Which ones didn't? Which were helpful and were helpful to you in considering a fair resolution of the matter?
Yeah. There was something you talked about in your last question to Matt, this notion of alignment and finding areas of alignment. And when Matt talked about really the specialty area for outside counsel to understand not only the industry that they're representing, but also the regulations and the government side of things, and how the government is going to be thinking about these things. And what really that comes down to is just really facilitating meaningful communication about the facts, the issues, the law, and a fair resolution. So you're right. When I was serving as the U.S. attorney and also as the PAYDAG, a lot of the things that were elevated to me were things where there were just material disagreements between either the section in the U.S. Attorney's Office or the component in the Justice Department and the outside counsel representing, the corporation or individual about what the fair resolution would be. And where I saw the most, I guess I would say, inefficiencies or problems, it's when the two sides were really struggling to communicate. They couldn't even really get on the same page as to what were the relevant facts, the relevant law and the guiding principles. And it sounds obvious, but it's really not. And I think that's because of what Matt identified. In the world that he practices in environmental justice, it's a specialty area. It really is. And so you can't, while there are good generalists out there, we've all met them, who can pick things up quickly. I think it does really help to have outside counsel that both understands, the client, the industry, and the legal landscape, and can also communicate with folks like Matt and folks, down at ENRD. So what I thought, was especially helpful is when outside counsel would come in and they would be working towards, fundamentally building empathy. In other words, identifying early on, that there were some things in which we could find agreement. In other words, there's no question perhaps what the law is. There may be few questions, frankly, about what the material facts were, but the argument would ultimately be, treat us fairly in terms of your punishment, whether that's a number in a settlement or a deferred prosecution agreement, or or to terminate the investigation because there'd been some misunderstanding. And, the questions I would ask, both in the Attorney's Office and as the PAYDAG, first question I would often ask is, what are the facts upon which we all agree? What are the legal principles upon which we all agree? So I could try to quickly narrow down to what the real area of dispute was. Some lawyers were very, very good at that, and some were, to be frank, either, I don't want to say flailing, but sort of thumping the table on the general equities. We're a good corporation, or this is a good individual. Why are you doing this? Why are you picking on us? As opposed to really getting into the heart of the legal analysis. And I think if you fairly want to apply the rule of law, equally, you have to understand the facts, and you have to understand the industry, and you have to understand the law. So again, it may sound obvious, but if you can early on establish, what's not in dispute, and then you can focus on where the disconnect is, right? And look, sometimes there was a legitimate disconnect because the two sides were just, failing to communicate. Sometimes that's, sometimes that's, because the corporation doesn't understand or appreciate, the government's approach to these things. And sometimes, frankly, it's because the government, is not a subject matter expert on that particular industry or that particular corporation or the way they do business. So there needs to be, I think, really effective education, quick, efficient education in the conversation on both sides, so that you can narrow the issues. And when lawyers approached me that way, look, we're not here to argue about X, Y, Z. We've really narrowed it to one or two things. And we need you to better understand us, so that you can treat us fairly. That was usually effective, to be frank. And I thought the same thing with the government. When the government comes in open-minded and says, we've been looking at you essentially through our keyhole. Maybe that keyhole is a whistleblower. Maybe it's a representation in a public filing. Maybe it's a news report. We've been looking at you through these, this keyhole or series of keyholes. And we think we understand you. but we want to get this right. We want to be responsible. We understand that there are consequences for you, even for the initiation of our investigation. Tell us what do we have wrong here, and then really listen. Really listen, because some of these industries, look, Matt does this every day, and so I'm sure he's developed over time, real subject matter expertise in some of the industries that touch on environmental justice, but not everybody has, and we typically, as lawyers, learn by doing, and so I think approaching it in that way, let me come in with an open mind. Let me see where there's agreement. Let me focus on where there's disagreement. And then let's all, work towards justice, right? Let's all work towards a just outcome. Maybe that means a punishment. Maybe it means something less, but trying to get everybody, aligned and at least on applying the same analytic framework to the same relevant facts, I think is critically important.
Matt, Seth mentioned the importance of communication a few times in his response. And are there any approaches or strategies that, in your experience, have been particularly helpful or even unhelpful in communicating with the government about potential environmental violations, whether it be voluntary disclosures, the supplemental environmental projects you mentioned before, or any other methods or opportunities to work towards resolution effectively with the government?
Sure. Well, to piggyback off some of what Seth said, I think the cooperation is really essential, and understanding the industry that you're operating in. But on top of that, many of in environmental cases, many of them are very record intensive, and so it's important for counsel to understand the record keeping requirements of the industry that you're operating in, and pretty much every major environmental statute has record-keeping requirements in terms of what types of records you are supposed to keep and for how long. And if you don't have those records, that's typically a violation right off the bat. And if you don't have good records on the types of things that need to be dealt with, and you're dealing with highly technical issues about things like emissions and wastewater discharges or how a Superfund site operates, then you're going to have a really hard time trying to figure out what actually happened and how it should be resolved. And that's additional cost and burden and time for everyone. There have been also, along the lines of cooperation, have been numerous policies over the years from the Yates memo, which was revised over the years, about making disclosures. The agencies have in the environmental space have pretty broad subpoena authority and information request authority. So cooperating with those is, of course, helpful, but also making a disclosure, sending the government a bunch of boxes of paper and saying, this is our response, and go spend a few years trying to figure out what we did is not, a great way to resolve an issue, because if the government is looking at the issue, they already know that there is an issue. So help by making a disclosure, explaining what you found and narrowing in on, what the key issues are so that the matter can get moved along one way or another. I touched, those are some techniques that are obviously important. I think particularly in current times, focusing on environmental benefits, if you're working on some type of resolution, is really important. As aside from whatever, penalty issues there may be, people who go to work in state regulatory agencies or environmental agencies or citizen groups that may be bringing enforcement cases, or the federal government, they, typically go into those positions often as a career. They're not necessarily interested in collecting the biggest penalty check. They're, see themselves typically as accountable to the community. And they want to bring environmental benefits to the community. And if, most federal cases are resolved by consent judgment, and a lot of state cases are resolved the same way, and they're typically put out for public comment. And I think if you look at most of those cases where there are comments, they tend to be from the public about the remedies. What is the public getting? What's the injunctive relief? Is it enough? Is it not enough? Is it not the right type of injunctive relief? Is it not something the community is really interested in. And I think those are areas where regulated entities can think creatively about the injunctive relief. They could consult with experts in the field. Maybe that's in air pollution or groundwater contamination or whatever it is, wetlands. Talk to those experts about what can be done. Consult with the community about what the needs are. That could be local government. It could be community advocacy groups. That's a central part of EJ. You can't do EJ kind of in your own mind with Google searches about what you should do. Part of EJ is talking to the community and addressing the issues in that community. So SEPs, we've talked a little bit about, were popular for decades. Those are not currently in play, but some states still do those, and including in cases that are joint federal and state cases. So there may be opportunities for those in state cases. There may be policy developments in the future where those could be done again. On the federal side, that's yet to be seen. Under past SEP practices, and with some states, a defendant can receive substantial penalty reduction for doing a project that benefits the community, and it's typically a project that relates to the type of violation at issue. So in an air case, it would be an air project, or in a water case, it would be a water project, things like that. Companies, when you're dealing with environmental justice issues, need to do research on where you're operating and what the environmental justice impacts are. There are a number of ways to do that. There's no one way that's like a silver bullet, and it requires some work and some thought. You could go to EPA's environmental justice screening website. If you just Google EJ screen, you'll find that right away. There are training videos and guides on the website about how to use that. It'll let you, let's say you have a factory somewhere, you have a smokestack somewhere, whatever it is, you could put in the address and it'll pull up what it calls indexes on different types of environmental burdens. So maybe it's air, maybe it's from health data talking about cancer risk in a community, maybe it's water pollution, Superfund site proximity. It'll pull that all up for you and show you where that site ranks nationally, statewide, and regionally. And that's like very useful for determining kind of where you are and what the EJ implications are. Some states also have their own EJ screen web tools. But the other way, what I mentioned is talking to the community. That'll, give you a lot more context on what you're seeing, using those web screening tools, and also looking at news articles about, what's happened in that community in the past. That'll also give you a lot of insight. So those are just some strategies that I think can be useful in identifying the EJ issues that may inform the approach that you take to resolve a dispute with a regulator.
Thanks, Matt. That's really helpful insight. And Seth, I just want to turn to you and see if you have any follow-up to that or any additional comments along those lines.
Yeah, I think, look, what really resonated with me with what Matt was saying is, Matt and his colleagues, they don't do this for sport, right? There's supposed to be, justice at the end of this, and you're supposed to leave the community, better than you found it. So if you take that approach, I think whether you're on the government side or the corporate side, everyone should be able to agree that we want people to be safe. We want them to have clean water. We want them to have clean air. We want to avoid the kinds of consequences that can flow from irresponsible, EJ or ESG, pick your terms. But we want to avoid these harms. And if there are harms, what is the most efficient and fair and just way? And look, maybe that involves punishment. It often does for general deterrence or specific deterrence of some kind. But I think in Matt's field and what he was emphasizing, and this really resonates with me, is, how do we leave the overall community better than we found it, through engineering some type of remediation here. And I think in this particular area of environmental justice, that becomes a clear objective than in some other types of area of enforcement where it might be a little bit more, a little bit more nebulous. Obviously, if you remove, a criminal from a neighborhood, you've hopefully left the community better than you found it. But it's that relates maybe to one individual or one group of individuals. Environmental consequences can be so far reaching and can have so many potential victims if not, handled responsibly, both by the corporate sector on its own initiative, living up to its own representations, essentially, and by the government with the leverage and the power of the United States government to fashion remedies and to ideally work in a cooperative way with corporations, to truly solve the problem in a meaningful way and to protect the community. So that's what I was thinking about, when Matt was speaking. And I think that, what it boils down to, for our corporate clients and, for those listening, many of us now are espousing these ideas in some one form or another. It's not really, I don't think it's really controversial in dispute to say it's a good idea to be environmentally responsible, socially responsible, and have good governance and to be mindful of these things. I think the ultimate question is, do your actions match your words? And are you spending enough time, internally on the front end in your corporation or when you're dealing with counterparties or engaging in transactions? Are you layering this thinking and this analysis into how you do business, or who you choose to do business with? Are you abiding by your own mission statement? And is that really becoming part of your culture? Because ideally, just knowing that Matt and his team are out there doing this kind of work should be, getting corporations to think about, are they doing it right? So they can hopefully avoid ever having to meet Matt in the first place, and if they do, going into that conversation, honestly owning failures, if there have been internal failures, proactively thinking about remedies so that they can come to the table, with a proposal, which is maybe good for the long-term viability of the corporation and the shareholders, but also recognizes, the importance of these laws and principles and values. So that's as in other areas of legal and enforcement, I think it really is important to not announce your values, leave well enough alone, and then hope you don't have a problem. I think you have to live your values, and in environmental justice in particular, because of the nature of the consequences that can quite literally spill out to others. You just have to make that consciousness and that compliance and that proactive thinking, whether it's critical incident response planning or regular communication, with those upon whom you rely to make sure you're running your operation safely. You just have to make that part of your daily thinking and part of your corporate culture. And if you do, I think you'll probably never meet Matt Silverman on the other side of a conference room table. And if you do, you'll at least be, well positioned to start the conversation, to get a fair outcome and a fair result from the department, or its regulator partners.
Thanks, Seth. And Matt, before we wrap up, any last comments from you?
Sure. I mean, I think there's a lot of developments in the field now. If you just looking in the news, you'll see it all the time. There's so many, with natural disasters and the focus on environmental justice. You'll see a lot, I think, and already have on areas like climate change. Climate change is a major area of focus that this administration has put out guidance on because impacted communities happen to often be located along industrial waterways. So when we have big storms like Ida and with Hurricane Sandy, EJ communities tend to get flooded, and the factories and facilities that hold hazardous waste tend to be located along those same waterways, which has, bears the risk of washing all that stuff across those communities that, have been burdened with that type of material in their backyard for years. DOJ and EPA recently released updated guidance on Superfund in the EJ context, and in an attempt to increase community engagement and input into the resolution of CERCLA cases, how work is done at those sites, and how the community is involved in that type of planning, which is also often for projects which go on for many years and sometimes decades. I think you'll see also, additional federal agency outreach to the community, and that'll also probably result in regulated entities doing outreach about their activities to the community, because the things that the government deals with are usually involve a regulated entity, though not always, because the federal government also does projects as well. The recently appointed new EPA administrator, Michael Regan, recently spoke about beefing up enforcement in environmental justice communities, additional hiring, targeted inspections, and things of that nature, which support the administration's Justice 40 initiative, which is again targeting, trying to get environmental benefits to reach 40% of those affected communities. And there are a number of guidance documents and policies that have been released, over the last 6 to 8 months that you could find on EPA's website or Department of Justice's website on these topics.
Thank you, Matt. I think that's all the time we have today. This has been a great webinar and incredibly informative. Thanks to both Matt and Seth for joining us today, and thank you all for joining us as well.